Hi, my name's Gina Toppin, and I'm here today to walk you through a interview for the Christian Legal Clinic when you come across a custody client. So we have a little presentation, and that will help us get through. I'll give you tips along the way, and at the end of the presentation, you'll be provided with a sample custody agreement that you can help your clients walk through to make it personalized to them. Here we go. All right. So we are working with Pennsylvania child custody. And the statute that we'll start with saying the types of custody that the court can award. The court may award custody for, generally speaking, physical and legal custody. There are multiple types of physical custody. Shared physical custody means that the parents share a substantial amount of custodial time. Usually that's considered 50-50. If it's not 50-50, then there's primary physical custody, which means that one parent has whatever it may be, 60, 70% of the time. And then the remaining parent has the partial custody, which is sometimes somewhat less of 50%. In certain circumstances, we do see sole physical custody, and that's where only one parent has custody of the child. The last physical custody actually is supervised, where the court has determined that it's in the child's best interest to not have unsupervised time with the parent. That supervised visits can take place at either the courthouse down at 1501 Arch Street, or it can be a family member or a friend who just watches over the custody time. And then as far as legal custody, that concerns the ability to make decisions regarding medical, religious, and educational decisions. That can either be shared 50-50, or one parent can have it, which is sole legal custody. With the statute that we look to when we consider who gets what time with a child is Section 5328. And there are 16 factors that the legislature has said we will look at when determining how the child should spend time with both parents. So what I do is I break down those 16 factors, and it helps guide the interview. If you see the parent jumping ahead, you can say, oh, well, hold on one second. We'll get to that factor around factor 8 or 9 or whatever it may be. So prior to conducting the interview, it's always helpful to review these factors so you know where to ask the client to politely put a pin in something and tell them that, we'll jump to that shortly. So I just copied the factors, and we can go through them, discuss what elements fall under each factor. Number 1 is which party is more likely to encourage and permit frequent and continuing contact between the child and another party. So that basically concerns when if one parent says, no, you can never have weekends, or no, you can't spend any time with the child. The court does not look kindly upon those type of situations. The present and past abuse committed by either a party or a member of the party's household. So this is important to always ask. Have there been any allegations of abuse between the two parents? Have there been abuse allegations between the child and the parent? Or if mom lives with grandpa, have there been any allegations that grandpa has abused the child? We have to look at all of those in order to assess what's in the best interest of the child. Number 3, the parental duties performed by each party on behalf of the child. There we look at who gets the child ready for school, who feeds the child a bottle or lays the clothes out for the child. All of those things are what we look at to see what is the past history of the parental duties. And it's important to keep in mind that the court has a rather short look back. So for example, if the parent was not in the child's life for the first year and a half, but for the last year and a half, they have been heavily taking care of this 3-year-old child, they get credit for that. We can't look back to the first year and a half and say, well, mom didn't participate in the child's life the first, half of the child's life, so we should say that they cannot do the parental duties. Number 4 is a need for stability and continuity in a child's education, family life, and community life. We look at that and we ask, has dad moved around every year for the last 5 years? What is the family situation like in his house? Do they have a regular dinner time? We just ask all of those questions just to kind of understand, is this a stable environment that we feel comfortable putting a child in, whether it's 20% of the time or 80% of the time? Next, we look at the availability of extended family. I always probe into the client's life and also the life of the other parent. I ask, do you have siblings? Are your parents around? Who's local? If they're not local, do you do family events for birthdays out of town, things like that? A lot of times this takes a lot of probing. Ask about cousins and aunts and uncles, because the more that the court understands that they have a large extended family, is the more that the court will award time so that the child can spend time with that family. The same thing goes for the child's siblings. If there are siblings that are not related to the other parent, it's important that the child sees their other siblings. So if dad's custody schedule for his other set of children is every other week, we might want to line this child's custody up with dad so that the kids can see each other. Number 7 is the well-reasoned preference of the child. And we do look at the child's age and maturity. So we use the rules of 7. 0 through 7, the judge will likely talk to the child just to see the child's demeanor and honesty, speaking with the children, see if they've been prepped and things like that. So they will look at the child, they will talk to the child at that period of time. That said, it won't be a determining factor in the judge's decision. When you move from 7 to 14, the judge will look at the child's decision and preference a little stronger. Again, it won't be a carte blanche, whatever the child wants, but the court will look at what the child says. They'll also see, do they want to go to dad's house because dad's the fun house? We don't have a bedtime. We can eat candy all we want. They look at all of those factors. And then from basically 14 until 18, they do look at they do put a lot of weight on what the child will desire at that point. The 8th factor that we'll look at is attempts of the parent to turn the child against the other parent. We do exclude domestic violence in this factor, but other than that, I ask questions like, do you know if dad talks bad about you to the child? Or has Johnny come home and said, well, mom said that we shouldn't come over here because? You have to probe a lot of questions because somebody might not realize that this is an attempt to turn a child against somebody. Which party is more likely to maintain a loving, stable, consistent, and nurturing relationship? That kind of speaks for itself. We just want to put the child, we don't want to put the child in a house where it's not loving, stable, consistent, and so forth. And just the way I'm going through these factors is how we will go through the interview as it happens. Another key to remember is in today's world, you can't assume that mom is the primary and dad is the secondary parent. So watch your vocabulary as you're giving examples. Don't always put mom in the primary custodial role, and don't always put dad as the weekend dad. You'll come across a lot of different variety of situations, and you want to make sure that both parents feel welcome and as though they can be the primary caregiver. Number 10 is which party is more likely to attend the daily physical, emotional, developmental, and educational needs of the child. This is, again, it's pretty clear, and a lot of this is based on history. So you have to ask the parent, when you guys were together, what did you do for the child? Did you get them dressed? Did you, if they skinned their knee, was it you that cuddled them? Things like that. With as far as the proximity of the residences, I ask for mom's address, I ask for dad's address, I Google the distance, and then very importantly, I ask, do you have a car? Does dad have a car? And then do you have to take public transportation? If so, how many buses is it? Things like that. That goes into play with dealing with the custody exchange and also the amount of time. If it takes dad 3 buses and 2 hours, we're probably not going to do an exchange that happens every couple of days. We might have to do an exchange that happens once a week or every 10 days, whatever it might be for the parties. The judges do look at this and they might say, well, mom, you have a vehicle, so you should be the one to meet dad, things like that. And just ask your parties about the willingness. Well, maybe one is willing to do all the pickup and drop-offs, so it won't be a problem. The other issue with that is if one lives in Pennsylvania and the other one lives in California, we might be looking at a custody agreement that says the California resident gets the children for summers and long holidays like Christmas break and spring break or something like that. So we use all of those to factor in how we assess custody. Each party's availability to care for the child or ability to make appropriate child care arrangements. This is important because if we have one party who works and the other party is a stay-at-home parent for whatever reason, we want to make sure that the court is not just awarding custody to the person who doesn't work because they are able to spend the time with their child. Parents are no longer chastised for having to go to work as long as they have an appropriate child care arrangement. And this often does spur further conversation. One parent might think that the other parent's third cousin, once removed, is not an appropriate child care person for XYZ reasons. All of those will be delved into during this factor. The next is very important. It's a level of conflict between the parties and their ability and willingness to cooperate. This goes on to 2 different factors. One, this will also help with assessing legal custody, because if the parties have such huge conflict, we might say, well, if there's ever an emergency decision, we can't do shared custody because they'll never come to an agreement, and that won't be in the child's best interest. So there are a whole set of factors that you'll look at for assessing the level of conflict and how that affects decision making. As far as the physical custody, we look at the level of conflict and we'll say, well, you know what? The 2 parents don't get along too well, so let's try not to do exchanges at each other's houses because that might cause a whole host of problems. So a lot of my orders, when I sense any level of conflict, I aim for exchanges at daycares and I aim for exchanges at school or extracurricular activities where one parent drops off at the beginning, the other parent picks up at the end. That's why exchanges on Fridays are always great. You kind of go into the weekend, whatever your weekend plans are, picking up the child from school, and then depending on how long you have them, you drop them back off on school on Monday or the next Friday or whatever it may be. But we like to separate, if there is any level of conflict, we like to separate the parents as much as we can. And we'll get more into that as we talk about drafting custody orders. So then the next one is history of drug or alcohol abuse of either the party or the member of the party's household. So again, it's important to remember if dad lives with cousin Susie and Susie has an alcohol abuse problem, we'll look at that when placing the child in that home. We look at the history of drug abuse and we say, is it relevant? Is it still active? If your client has the drug abuse in their history, find whatever certificates they have that they've been clean. If they're in Narcotics Anonymous or, or any type of program like that, bring certificates showing that they're good, that they have not relapsed. And also, let me just say, have your clients be very honest about their drug use or even their alcohol abuse, because at any point the court can order a drug test. I've had clients sent out or opposing parties really sent out in the middle of a trial to go upstairs and take the test. So let them know that if there's dishonesty detected, that might happen right then and there. And the court can just say you get no custody or you only get supervised visits. Similar to drug and alcohol abuse, we look at the party's mental and physical condition and the mental and physical condition of somebody in their household. Again, if you have a client who has, some type of, whether it's bipolar disease or an anxiety disorder, and they're well medicated, they see the proper medical professionals and it's not a problem, be prepared to present that evidence as well. The same thing with the physical condition. If, say, for example, they have multiple sclerosis and it's well checked, there's nothing to worry about as far as a physical ailment at the time, bring all that evidence to discuss with the court at that time. If there is a physical ailment that is remedied, bring that evidence to the court as well. The biggest thing is let the court know why this mental or physical condition will not inhibit your custody time with your child. And then the last factor we have is a general catch-all, any other relevant factor. This can be a whole host of options. In the past, I've had issues such as one child was heavily into a basketball program where they traveled all over the states, and it was an issue where mom wanted heavier participation than dad, and that was an issue. I've also had an issue where there was a one parent with an extremely religious with a set of beliefs, I'll say, and the one parent thought that that was detrimental to the child. It was taking up too much of their time and so forth. So anything that doesn't fit into one of those 15 factors, that's where we play that catch-all group. And you have to make sure you explain it to the judge very thoroughly, because a lot of times when it's something like a religious belief system, you can't just go in there and say, well, she's very into her religion. You have to break down their beliefs and so forth and all of that and tell the court why you believe it's detrimental to the child. Another important factor when we're looking at custody outside of the 16 factors is, have either parent or a member of the household been convicted of this certain set of crimes? So what we do is we look to section 5329 and we see, have they been convicted, pled guilty, or no contest to any of these offenses? They are things like basic possession, which you might come across a lot in dealing with clients, which I know I have when I have a wide variety of clientele. That's not one of them. So let's take a look at the list just generally. They're pretty serious crimes: stalking, kidnapping, homicide, aggravated assault. A lot of them involve crimes dealing with some type of sexual nature. So that's why the court is very concerned that, is this a home that we want this child in? That said, if there are any convictions or guilty pleas or no contest in the household for any of these, it's not a complete bar to getting custody. They will have, whoever it is will have to undergo testing, dealing with mental health professionals to see if they are still a harm to the child. If it's, maternal grandfather who was convicted of aggravated assault 50 years ago, the court might say that was in the past, there have been no types of reoccurrence, and so we feel comfortable placing this child. It just depends. It's very case to case. Here are a few more of those. So just you can take a look at them and scan to see what type of offenses that the court is truly concerned with when it comes to placing a child in the house. I just wanted to give you a few notes on how to draft a custody order. I always say the devil is in the details, and a family law case is like a handprint, like a palm print. No two people are the same. So everybody needs to have a custody order that fits them. And my goal in drafting a custody order is to let this custody order last as many years as we can. But what you'll come to see as you deal with more families is there are certain times where an amendment is kind of needed. So the biggest example I say is we might do an agreement when the child's in daycare and they have a very flexible summer schedule. They're not doing sleepovers, and they're not doing sports after school. But once that changes, maybe every other weekend with dad doesn't work because those weekends are taken up with things. So we will discuss, how do you see the custody? How much time do you want? And this should be the guiding force in what you want, because some people don't want 50% of the time. Some people say, I want to see my child every other weekend. But different types of common custody agreements, we can do every other weekend and one night each week. There's 5-2-2-5, which means 5 days on, 2 days off, 2 days on, 5 days off, and the same with 4-3-3-4. Then there's basically 50-50 that can be typically week on, week off. In the custody order, it's very important to include who, where, when, and how. If there's a problem with stepmom picking up, make sure that both parties agree stepmom won't do pickups from the other parent. Where? Is it going to be at school? Is it going to be at daycare? Is it going to be at grandma's house? Is it going to be at mom's house? When? What days? What times? And the how is important when you have younger children. Does dad come up to the house and get the child? Are the children old enough to walk from mom's front porch to dad's car alone? Things like that. Some of that deals with the conflict situation. Holiday and vacation schedules, discuss those. Let's always think about the federal holidays. Think about religious holidays. Is your client Christian? We've had Muslim clients through the clinic, so you have to always think about that type of thing. Typically what I do is larger holidays like Christmas and Thanksgiving will alternate. So if mom has Christmas in 2021, dad will have Thanksgiving in 2021, and they'll switch in the even years. And then I pair up holidays such as Memorial Day and Labor Day, and Martin Luther King Day and President's Day go well. So when one parent has the even years for holiday A, they have the odd years for holiday B. Vacation schedule. It's depending on how your clients do have vacations. My standard agreement, and I deviate from there based on the family, is I say you must give 60 days notice. You can have 2 non-consecutive weeks of vacation, and you just have to send the other parent the basic information, flight info if you're flying, where they'll be, things like that, general information. And with your client, you can decide how in-depth you want to go. And then the last part that I find important in dealing with custody agreements, specifically when there is high conflict, is how will the parties communicate? Are we going to say you must only put everything in writing via text and email? Are they allowed to have phone calls? The other part is maybe you only have phone calls when somebody's running late and they might not check an email, or they're not responding to a text. Another common thing that a lot of parents with younger children who need supervision is sometimes a parent will want phone calls. I will warn you that oftentimes this is a huge issue when one parent wants to be able to talk to the child every night they're with the other parent. Timing is always an issue, but if it's a must that the one parent wants, set it right before bedtime. Hopefully the child has a typical bedtime at their house, and so forth. But I just counsel you be careful in doing that, because it always creates a lot of problems. And those are the general gist when drafting the custody orders. Let's see, just a few final thoughts. Knowing when and if to file. A lot of times when people come to the clinic, there's kind of information gathering. So it may or may not be the right time to file. So for example, if a young child comes in 2-3 months old and the dad hasn't truly asked for a large amount of custodial time, we might want to say it might not be time to file yet. Either they can work something out together, or there's just no reason to get the court involved if dad's not asking for time just yet. When people have to go into court, it just causes, time off work, more conflict and things like that. So sometimes I'll tell people, take this information, understand it, and then when you find there's time, it's now time to file, then file. I also make a caveat, if you also don't believe that the other parent will take the child for an extended period of time and not return the child. If you have that feeling, then it's best to file immediately. For the most part, it's important to know that custody and support do not intersect. The only time they do intersect is when one party has the child more than 40%. I should say both parties actually have more than 40% of the time. If somebody only has every other weekend, they're going to pay full support and it won't matter. It's once you get basically 3 out of 4 days is when you get a reduction for support. And the last thing I'll say is custody agreements are always modifiable by agreement of the parties. That means if dad has a family birthday party on mom's weekend, it's okay. Encourage them to swap weekends. Do a makeup time the next weekend. If they want to say, you know what, let's switch from 40-30 or from 40-60 to 50-50, that's fine. You don't need to go back and modify the order if it's working for you for the two parties. The courts like to not babysit the two parents, allow them to have the flexibility to make it work for their family. Courts tend to get very annoyed when you walk in and the file is 3 inches thick and the child's only 4 years old. So the more the parents can work out on their own, encourage that. I just tell my client, write an email, have the other parent say, yes, I agree. This is our, interim order, or our interim agreement, I should say. Then the last thing to remember about that is whenever there is a disagreement, if mom says, I no longer want to do 50-50, I want to go back to 40-60, you must go back to the agreement because that is what is the last order of court. And if the one person is unhappy, then you seek to modify. You have them file a modification to custody. And those are really the key parts of how to conduct the agreement or the interview, what to hit as you speak with them, and that's it. Like I said, attached you will find the model custody agreement. And if you have any questions, always feel free to reach out to the clinic. They can either get a hold of me or answer the questions for themselves. So thank you for attending this session.